answer any questions that you have in the chat. And this session is being recorded for educational purposes. And you will have the opportunity to ask any questions at the end of the presentation. Okay. And our guest speaker, make sure she's on here. I'll give her proper introduction. Okay, it's my absolute honor to introduce our guest speaker for this evening. Attorney Jammie Smith Taire is a proud Georgia native and graduate of Georgia State University College of Law. She has been practicing law for over 20 years and has dedicated her career to protecting families throughout the estate planning and probate service. She began her legal career at a firm in Gwinnett County, where she oversaw the wills division. And in 2006, she launched her own successful law practice. Today, she focuses on estate planning and probate, and also serves our community in a powerful way, including servicing as a magistrate in Gwinnett County and as the chief judge of the Municipal Court of Snellville. Beyond her legal career, she is also a devoted wife and proud mother of a 15-year-old son. Her work speaks through her service, integrity, commitment, and educating families. Please help me welcome Attorney Jammie Taire. And Attorney Taire, the floor is officially yours.
Thank you so much. Thank you for that warm welcome. And I want to apologize in advance. I am having technical difficulties. I have been on with Tina for the last 30 minutes trying to get my computer straight. So hopefully it's okay. It's still a little dark. That's because I've changed computers 3 times while trying to get on this presentation. But I am so happy and honored to have the opportunity to speak to you all tonight. Anytime I have the opportunity to speak to a group of people regarding estate planning and presentation, it is my honor to do that. Before I begin, I see that my law partner is on here as well. So I want to introduce you all to her. Her name is Jabrina Johnson. You see she's waving down there. And I want to thank her for joining today and supporting me as we move forward on this. We have a newly formed law firm called Perimeter Law Group. Both Jabrina and I've been in practice over 20 years. Jabrina, I'm not sure you're close to it.
19 this month.
So with you tonight, you have 39 years, well, probably 40, because I think I've been over, 1998. So you have over 40 years of combined legal experience with you tonight to give this presentation. And as she already said, I'm a Georgia native. Jabrina is born and raised in Mississippi, and she went to the Jackson State University. And Jabrina, since Tina already introduced me, I'm going to give you the opportunity first, before I start this presentation, to give them a little background about yourself.
Well, thank you so much, Jammie. And also, Tina, it's absolutely an honor to be here tonight and to have the opportunity to present to people from our community, because as passionate as you expressed your feelings about estate planning and how important it is for us to plan for our families in future, I feel equally passionate about it. So I always appreciate the opportunity. As Jammie said, we are law partners. We've both been in private practice ourselves separately for quite some time. We decided to come together. Our firm is Perimeter Law Group. As she said, I'm a native of Mississippi. It's 2 things I love, and that's Mississippi and Jackson State. Everybody knows that. So I'm a big JSU football fan. And we're about to be 2-time HBCU football champs this year. So y'all can check that I said that. But I've been in Georgia now for 21 years. Our firm is in Gwinnett. Love and enjoy what we do, but more importantly, teaching and asking questions that a lot of us don't like to talk about and don't like to answer, but getting people more comfortable with that. So that is my goal, and I'm going to turn the floor back over to Jammie and let her run the show.
And she just told you all something that was not true. She said there are two things she's passionate about. That is not true. She is passionate about Jackson State. She is definitely passionate about the law because we've been opposing parties. So those two things are true, but she left one out. And Tina, what was that she left out?
Delta Sigma Theta Sorority Incorporated.
This is true. This is true. This is true.
She is definitely passionate about that, but we've wasted enough time. Let's get started. Unfortunately, I am not going to be able to show you a slide presentation, but that won't change the information. That just means that you have the opportunity to concentrate on my face more than you're going to have the opportunity to concentrate on the slides, but the information will be the same. And I know that you're all muted just so that we can try to get through this information and get it to you. And we offer consultations. So if after this you want to have a consultation, we have an intake person. There's no charge for the consultation. Usually it lasts about an hour and a half. So if there are additional questions after this that we don't have the opportunity tonight to answer, we'll provide our information. Jabrina, if you could drop that in the chat for everybody, we'll make sure that you have that information available to you so that you can always follow up. But we will also have a Q&A session at the end of this. Just a disclaimer, we always start the presentations this way. Even though we are both attorneys, we are not your attorney as of yet. So this information is being provided to you, but it does not create an attorney-client privilege between us. So in other words, if you say something about somebody and they call us, we might tell them. So just realize that this doesn't create an attorney-client privilege. The things that we want to talk to you about today are the things that are essential to estate planning. Like Tina said, one of the things that we've come to discover is that not enough people understand the importance of estate planning. You'd be surprised to know that I think it's over 63% of Americans don't have anything in place. That's not a will, not an advance directive, not a power of attorney, or anything at all in place. And that's tragic because if something happens, then they're going to have to go through the probate process and it can be really costly and expensive. The things that I tell people when they come into my office and they say, Jammie, what are the basic things that I need to make sure that my family is protected? There are three things that I tell them they must have. One is a will, two is an advance directive, three is a power of attorney. And if they want to avoid drama, I also suggest a trust. And that has actually now become one of the essential tools that we also tell people. We used to just say do a will, a power of attorney, and an advance directive. Now we tell people if you can, we also strongly encourage you to consider getting a trust as well. So tonight I want to go over what those documents are. I wish you were on screen because I could ask this question and maybe by show of hands, if you can show me how many people actually have a will in place. If I could just, if you know how to do the raise your hand icon. So I can sort of know how many, what I'm dealing with. I don't see any, I see a couple hands raised. What about a power of attorney? All right, I see one hand raised up there. And then we have the advance directive. So I'm going to start with some things that you need during your lifetime that are important. The first thing that you need is an advance directive. The advance directive is the document that says in the event you have a medical decision and in the event something happens to you, who's going to make medical decisions for you? This document is important during your lifetime and is important because if something happens, you think, well, it's next of kin. It's not automatically next of kin who makes those decisions for you. So if you want to have any say-so in who's going to make those decisions for you, then you need a medical directive. But a medical directive doesn't just say who's going to make those decisions for you. It also says what happens in the event you're on life support. So say, for instance, you're in an accident and you're on life support. It goes to whether or not you want to be on life support, and an advance directive allows you to make that decision in advance. It also allows you to say things like whether or not you want to be buried or cremated and who you want to be guardian over you. So let's just say, for instance, you are driving down the street and you're involved in a car accident. You go to the hospital and you're unable to make decisions for you. Right now, if you don't have an advance directive in place, then who are they going to turn to? The obvious answer sometimes is like, oh, it might be my wife if I'm married, or it might be my kids if I'm not married. But what if your children can't agree? Or what if you don't have a spouse, but you have a partner who you've been with for a long time and you want that person to make the decisions? Well, that person wouldn't have the opportunity to make that decision if you didn't have a medical directive in place. In addition, it becomes important if you want to or don't want to be on life support. Like some of us say, hey, if something happens to me, I want you to discontinue life support. I don't want to have to lay up in the hospital. Other people say, keep me alive no matter what. Well, if you have an advance directive in place that you've already signed, then your family knows what your wishes are and there's no argument. The next document that's important to have is a power of attorney. The power of attorney is the document that says who you want to make financial decisions for you in the event you're unable to. Now, this document is very powerful. In fact, I say it's one of the most powerful documents that you sign, more important than an advance directive or a will, because it allows someone to practically be you. So say, for instance, you are in an accident and otherwise unable to make financial decisions for yourself. What's going to happen to your family? They won't be able to access your bank accounts. They won't be able to call the mortgage company. They won't be able to call your credit card. But if you have the power of attorney, then this allows them the opportunity to do that. The power of attorney takes effect during your lifetime, but it dies when you die. So when you pass, the power of attorney is no longer effective. This document is very important in estate planning. Next, we have the will. The will is the document that says where you want your assets to go in the event you're unable, when you die. So with a will, you get to say where your assets go. Many people think that your assets pass to your, that they go to the state if you don't have a will in place. That's not true. In Georgia, if you don't have a will in place, if you're married with a spouse, and you have children, it goes to your spouse and your children. If you don't have children, then it goes directly to your spouse. If you don't have a spouse, then it goes to your children. But it doesn't go to your spouse automatically. It goes to your spouse and your children equally. So say, for instance, you're married and you have 3 children. Then in Georgia, if you don't have a will, that property passes to your spouse and your children equally, with your spouse taking no less than 1/3. So your spouse will get 1/3, and however many children you get, they would get the remainder. Well, many people don't want that to happen. They might want their assets to first go to their spouse and then to their children. If you don't have a will in place, this is not how it's going to happen. It's going to go to your spouse and your children, no matter the age of your children. So it's important that you have a will in place so that you get to decide how your assets pass. Now, many people sometimes go online and they do their own will. In Georgia, in order to have a valid will, you have to have certain things in place. One, it must be in writing. So even though we like the idea of doing a video, we see it on TV, it's a nice idea, in Georgia, that does not make a valid will. It must be in writing. Now, it doesn't have to be typed, but it does have to be at least handwritten. Another thing that you must have is it must be signed by 2 witnesses, and they must see you sign it and you must see them sign it. So I think we're all familiar with the Aretha Franklin situation where she had her something written down and they found it in the couch. It was on a napkin. Now, if it would have been signed by 2 people and by Aretha, it would have been valid. But if it was not signed by Aretha and 2 people in Georgia, it is not valid. So it has to be signed by you and 2 people. Many people think it has to be notarized. It actually does not have to be notarized. Now, you should have another page that's called a self-proving affidavit so that they don't have to look for the witnesses, but it doesn't have to be notarized in Georgia. So you need your signature, two signatures, and of course you must be competent to sign it. And competence is presumed. Sometimes people come to us and they say, well, my mom or dad has dementia. In Georgia, so long as they have a lucid interval, in other words, when they sign the will, as long as they're lucid when they're signing it, then it's still deemed to be a valid will. You just have to make sure that the person understands what they sign when they're signing it. Next, one of the things people are really starting to come to us about lately are trusts. And they say, well, I heard that I need to do a trust in order to protect my assets or in order to avoid probate. That is very true. In order to avoid probate, what you need is a trust in place. The trust will help you avoid probate and help the fights, or they help to make sure that once you pass, that your assets pass without the need to have to go through the probate process. So what is a trust? A trust is just like a will. In other words, it's the same thing. You still get to decide where your assets go, but in the end, you don't have to go through the probate process. So you would come, we would put your assets in the trust, we would fund the trust, and once your assets are in the trust, then when you pass, your family doesn't have to go through the probate process. It would just pass through the trust. There are a couple differences between a will and a trust. One, a trust is private. With a will, when you pass, it has to be filed with the court. So anybody can go down to the courthouse, see that you filed your will, know who you have left your assets to. With the trust, that is not the case. It is a private document, so you don't have to worry about anyone seeing or accessing your information. The second difference between a will and a trust is that a trust takes effect immediately. That's why it's called a living trust. A will does not actually take effect until you pass. So with the trust, when you come to our office or you go to an attorney and they set up the trust, they put your assets into the trust. At any time, you can revoke it, amend it, make changes to it, do whatever. But it's a living, breathing document. So you can continue to add assets to it. With the will, it isn't actually in effect until you die. And one of the things people don't understand is that it's really not deemed valid until the court says it's valid. So when you pass with your will, the executor really isn't supposed to do anything until they file it with the court, notify all the parties, and then the court says that you can act as the executor. That is not the same with a trust. A trust continues on. So when you pass, they don't have to go through court. They don't have to notify any relatives. They don't have to get permission from anybody. They just do whatever it says that you've outlined in the trust. The same is not true with the will. You do have to file it with the court. The judge has to say that this is a valid will, and then they have to appoint whoever you've named as the executor over the will. So sometimes what happens is when you pass, it can take a while before they can probate your will. During that period of time, things are happening, like your bills are not being, or things are not happening, like your bills are not being paid. Your mortgage may not being paid, may not be able to get paid, and sometimes foreclosures even happen. So a trust helps avoid that time when that period. Another major difference between a will and a trust, and I'm sorry, I'm looking at my presentation while I'm doing this. Another big difference between a will and a trust is that notice. So with a trust, you don't have to put anyone on notice. With the will, you do have to put your heirs on notice that the will has been filed, even if they're not included in the will. So those are the major differences between a will and a trust. Now, what happens if you have a will and you die? When you pass and you have a will, you have to file the will with probate. So you go down to the court, as I've stated, They file it with the court. They have to notify whoever your heirs are to see if they're going to consent or object to whoever you've appointed as the executor. Once they're appointed as the executor, it has to run in the paper once a week for 4 weeks. After it runs in the paper once a week for 4 weeks, then the executor is appointed over your estate and they can do whatever you've outlined in your will. With the trust, they don't have to do that. Once you pass, then they can just start doing whatever it is that you've outlined in the trust without having to go through court to get permission. So the important documents that you need to have are an advance directive, a power of attorney, a will, and a trust. Well, you're saying, well, Jammie, you just told me I need a trust, so why are you still saying I need a will? Well, you still need a will just to make sure you don't die intestate, and that means without a will, because sometimes there are things that you don't put into your trust. So if you don't put those things into your trust, then you still want a backup will so that you can make sure that your assets pass like you want them to. For example, I had one couple who we completed a will and a trust for them. But after the husband passed, some money came to the wife for the husband. Well, that money wasn't included in the trust because, of course, we didn't know about it. So in his trust, he had disinherited his children. Had we not had the will, then his children would have gotten a part of that money. But because we had the will, which had also disinherited his children, then the children did not have access to that money. And that was very important to him because he was estranged from his children. So that's why you still need a will in place, even if you have a trust. So I've gone through that a little quickly. Please let me know if you have any questions about anything that I've said so far. Tina, I think you have everybody muted though.
Yes, well, everybody, yeah, those sorts to say, is it okay if they just unmute themselves if they have a
Yes.
question? So if you have a question, anybody, you can unmute yourself. And if you have an issue with unmuting, let me know, which I don't think you should. Let's do it. Do we have any?
Yes, I have a question. Hey Tina, you look
Hey, Miss
so
Darling.
pretty.
You too.
What if my house isn't paid for? Can I still put it in a will or a trust?
Absolutely. So most people houses aren't paid for, right? I wish
Mhm.
we all wish that our houses were paid for, but most
Right.
of us don't own a home. The most popular kind of trust is what's called a revocable or a living trust.
Mhm.
And so if you have not paid for your home, then you're going to put it in a revocable or a living trust. You can't put it in an irrevocable trust, but you can put it in a revocable trust. That won't affect your mortgage in any way. They won't accelerate the loan. It won't affect your property taxes. The only thing it does is move that asset into the trust so that when you pass, your family doesn't have to go through probate.
Okay. I have another question.
Oh, go ahead. I went through the presentation really quickly, so I'm welcoming
Okay.
questions.
Well, I was taking notes on my phone while you were talking.
Okay.
I just recently got married. My husband and I are both older, and
Uh-huh.
he has told me that he doesn't want the house. So what would I do? I mean, would I just put it in
So
my children's names?
well, okay. So sometimes people come and they say, should I just transfer my house into my children's name? My answer to that is always a resounding no.
Okay.
And that's during your lifetime. And the reason why my answer to that is a resounding no is because let's just say, for instance, you decide you want to sell your house, right?
Mm-hmm.
But you put it in your children's names.
Oh,
So
wow.
now you have to hope that they will let you sell the house because it's now in their name. Now you can put it
Wow.
in the trust and you can still sell it. And in the trust, you can leave it to your children.
Okay.
But no, do not put your house in your children's name. And not just because you now have to go to them and ask them if you can sell the house, but you also don't want to put it in their name because let's just say, for instance, they have creditors. They
Right.
could put a lien on your house.
Oh, wow.
What if they get married? Then their spouse might be entitled to a portion of your house. So during
Wow.
your lifetime, it's not a good idea to put your house in your children's name. It's not even a good idea, in my opinion, to add, and I have a child, it's not even a good idea, in my opinion, to add them to your deed. for the reasons I
Wow.
just said, if they get in any kind of financial trouble, or if you decide you want to sell your house. And, my mom and dad, I came from a strong family with strong parents. But no matter what you do to those kids, you can threaten them, do whatever you want. But if they don't want to sell that house, they don't have to. And you can
Wow.
take them to court, and there'll be nothing that the judge can say, well, you put it in their name. So, no, it's not a good idea to put the house in your children's name during your lifetime, but you can transfer it to them through the trust.
Okay, thank you. This has
You're
been
welcome.
so informative. Thank you, Tina, for doing this. This has been wonderful.
I see Janice's hand raised.
Okay. Janice.
And Jamie, while she's unmuting, someone put in the chat and asked if you could differentiate between a will and a pour-over will.
Yes. So they're the same thing. A will, we call it a pour over will when you have a trust, because it's basically saying that whatever I forgot to put in my trust, I want it to be included in my trust. So we call it a pour over will, but it's the same thing. Just a pour over will accompanies a trust. But on your will, when we prepare your documents, it doesn't say the word pour over will. That's just what we call it.
When you said Janice, I don't see
I
Janice.
see her hand raised, but
Is it? Okay, maybe she's having an issue.
okay.
If I don't see your hand up though, but. Okay. Do we have any more questions, comments, or just, points of clarity needed from the presentation?
So I'm going to, while they're doing that, I'm going to give you a couple of what I call probate hacks. So in addition to a trust, which is the ultimate probate hack, another couple things that you can do to help avoid probate is, one, on your bank accounts. You can make sure that you have what's called a payable on death or a transfer on death on your bank accounts. So you can either go to the bank and tell them you want to add a beneficiary, or I know like with Bank of America, you can do it online. So that means that if you name a person as a payable on death or a transfer on death on your bank accounts, then that asset will pass to them without having to go through the probate process. In addition, if they're a joint account holder on your account, then that money passes to them also without having to go through the probate process. Anytime you have anything where you have a named beneficiary, like a life insurance policy, a money market account, your 401k accounts, anything with the named beneficiary, that money passes to whomever the beneficiary is. So it avoids probate. One thing you do want to avoid, though, with those accounts, though, is saying, oh, well, I'm going to leave the money to Jabrina, and Jabrina knows what I want her to do with the money. That's a bad idea. You should leave the money to whomever you want it to go to. Now, if you're leaving it to minors, that's another opportunity for you to use the trust, because then you can leave that asset to the trust, and the money in the trust, you can say what happens to that money. So that same money that you were going to leave to Jabrina and say she knows what is supposed to happen with that money, you can leave to the trust instead, and then Jabrina has to do whatever you said you want to see happen with that money. In addition, if you have minor children and you don't want them to necessarily get a windfall when they turn 18, through the trust, you can say how you want that money to pass. So you can say at the age of 21, I want them to receive a certain amount. At the age of 25, I want them to receive a certain amount. At the age of 30, they get whatever amount you've outlined. You can also put conditions on it. So you can say things like, well, they have to go to school, or they have to have a trade before they can receive certain funds. So that's another benefit of transferring that asset into the trust, because then you get to outline how it's going to be spent. Another thing that's been coming up lately with the trust are what we call life estate interests, because of course we're all about legacy building and wealth building, right? But sometimes we have children who we might not want to leave our house to outright because we're not sure they can take care of it. but you know that they need a home, especially if they're living with you. Then you can leave them through the trust, what's called a life estate interest. And that's where you're saying, I'm allowing so-and-so to stay in this house during their lifetime. And then once they pass, or after a certain condition is met, then the house can be sold and divided. So a trust also affords you that opportunity. Is it a good idea to have a bank account in the name of the family trust? It depends. So it depends on what your assets look like. I don't like banks as far as trusts are concerned. That's why I always suggest that you name the trust as the beneficiary with your bank account. But yes, you can earmark a bank account to your trust. So you can open up a bank account in the name of the trust and put money in it specifically for that purpose. Or on your accounts, you can just name the bank, you can just name your trust as the beneficiary, and that money will just pass into the trust that way. That's my suggestion.
Kiana has her hand up. Kiana, are you able to unmute yourself?
Now I am. Thank you. I wanted to circle back. I think you mentioned where somebody can stay in the home for their lifetime. So would that be within the trust with the conditions?
Yes. So
Okay.
that's what's called the life estate interest or right of occupancy in the property. So you say they can stay in the house and certain conditions have to be met. You can even say they have to pay the mortgage or they have to pay the utilities. They have to make sure the house is in good repair. And the trustee, whoever's serving as your trustee, would sort of oversee that. And then, like I have some people say, well, I want my child, something happens to me, I want my child to be able to stay in the house until they turn 21. And then when the child turns 21, you can say the child can either keep the house or the house can be sold and the proceeds divided however you've outlined.
And Kiana, I just want to piggyback off of that. I think the beautiful thing, when it comes to a trust is it gives you all the power, right? Any scenario that you can think of, for the most part, we have the ability to outline that in your trust. In doing a lot of legal reviews, people have a lot of circumstances, and they can be really unique. And so we've had situations where someone will say, they'll essentially create what we used to call trust fund babies, right? So they'll say, hey, you pay, as long as they're in college or as long as they're going to trade school, I'm going to pay for a car, an apartment, or a mortgage for, 4 or 5 years. After that time, then, they'll get this amount of money. And then so we've written them so that people have monthly stipends. We've written them so that one of my clients, she was a family law client. Now she's our estate planning client. She has two very small children and her mom lives with her. So we have a situation where mom can stay in the house and help to raise the children until the children get of age, but the house can't be sold, right? And then even at 18 or 21, kids may think they want the money. So she put a provision that said the house can't be sold until both children turn 25 and they have to agree to sell it. So you could be as creative or as simple as you want to. At the end of the day, you paid for it. This is your money that you work for, your property that you work for, and you should be able to outline what happens to it when you're no longer here.
Are there any other questions? Well, thank you all for allowing us the opportunity to speak with you today. I think Sabrina has placed our information in the chat. As I stated, if you would like to set up an appointment to further discuss your particular circumstances, we are happy to do that. We offer a consultation with our intake coordinator, Kevin Lewis. He is also a financial advisor, so he can also help you with those questions that you may have, but that is at no additional cost to you.
Nice.
And somebody said they've already had a consultation with Kevin and he was, today, and he was great.
Looks like Sophia. Okay, let's see. All right. Well, thank you so much. I want to sincerely thank each and every one of you for taking the time out of your evening to join us. And this is all about empowerment. And as a broker, I probably worked with everybody. I see Kiana. Kiana's a realtor in the office there, Kiana Gatlin. She has a few guests on the call as well. We sell houses to you, right? Well, it's our responsibility to also make sure that you are armed with all the knowledge needed to protect those assets once you acquire them. So this is why we have this, free event for you with our wonderful attorneys here. So we thank you so much for your time. And this is just, information for you to hopefully take and secure your assets.
And Tina, before you go, I just want to say one thing when you said
Sure.
a realtor. Have you ever had the situation where you're getting ready to do something with the house and you can't because it has to go through probate?
Oh yeah, we're going through that right now. With another client, and it was actually quite unfortunate. Her mother had a terminal illness,
Mhm.
and she executed a power of attorney. And they thought that the power of attorney would allow the daughter to proceed after death if anything happened unexpectedly. Well,
The
it
power of
did.
attorney dies when they die.
Power of attorney, exactly what you said. The power of attorney died with her mother. So now she's having to go through probate to, get all the assets cleared and become the executor over the estate. But
Mhm.
I've definitely had a lot of clients this year having to deal with just inheriting a property. Or trying to figure out how they can secure their assets for children or whomever. A lot of second marriages are coming up where, children are involved and the kids are not able to get, their inheritance because of second marriages. So it's
Mhm.
it's a lot of sticky situations, which is why this information is truly valuable and important.
And before we go, I just want to say that of course, we think it's very important that you have a trust and a will in place, but also, equally and maybe more important during your lifetime, please make sure that you have an advance directive and a power of attorney in place because you never know when something's going to happen. And those are two of the things that can really save you a lot of time and money. Because if you don't have a power of attorney in place and something happens to you, your family is going to have to go to court. And I don't mean you die, I mean you just incapacitated. Your family would have to go to court and apply for guardianship. The filing fee for guardianship is over $600. That's just the filing fee. That doesn't even include the attorney's fees. And that could easily have been resolved if you would have just done a power of attorney. So, or a medical directive in case your family's fighting about what's going to happen to you in the hospital. So, if you don't take away anything from this call, even though we've talked a lot about the trust and the will, which are very important, especially when you pass, please take away that while you have your right mind, that you need to get a power of attorney and an advance directive in place because that alone, just those two little documents during your lifetime can really save your family a great deal of worry and, quite frankly, money.
Let's see, I'll make sure we didn't have any more questions. And Darlene had a good question. She said, I have young kids. Can I place their care in trust? It looks like Attorney Johnson answered that. Darlene, did you see the answer to your question?
I did see it. I did. Thank you all.
Great, great, great.
Darlene, I know you got to make an appointment.
I definitely need to.
And Tina, I was just gonna piggyback on that too. Jamie didn't hit on this, but we often talk about it. A lot of times kids turn 18, they go off to college and they think they're grown, but we all know they're not grown. But the law says that they're adults. So one of the things that we love to do, especially around July and August when it's back to school time, is we do run uh, a special for getting POAs, right? For your kids that are going off to school, because you never want a situation where you can't get in touch with your child, you don't know what's going on. And there are some schools that protect children's privacy. Just because you're paying the bill doesn't mean that you get access to go into their room or you get access to their medical records to find out what's going on with them. But you may need that because even though the law says they're an adult, they're not really an adult yet. So that's just something for people to think about as well. You know, we also do power of attorney for your young children that may be turning into adulthood, but also need some support and guidance from you as a parent or a guardian.
It's great information. Well, thank you all again. Thank you so much, Attorney Taire, Attorney Johnson, for your time this evening. And I'm gonna say going once, going twice on questions. Any questions? Let's see here. Make sure. All right. Well, thank you all again. This call is being recorded, so you will all receive a copy of the meeting. So that way you can just go back through and ask yourself questions again. And if you have any questions, you can reach out to Attorney Taire, Attorney Johnson, and their information is in the chat. Okay. And all right. Thank you so much for attending, and you guys have a good night. Bye.
Bye-bye.
Thank you. Bye-bye.